As of August 2026, every document Claude touches carries an invisible watermark. Every advice letter, every skeleton argument, every clause Claude helped you refine, every document Claude proofread, every translation Claude produced, all of it marked, invisibly, permanently. The general coverage of this development has focused on user backlash and whether people will get caught using Claude at work or in classes. That is not the lawyer's question. The lawyer's question is, what does this watermark mean for professional conduct? What does it mean for court filings? What does it mean for client documents? And what does a firm need to decide before the detection API goes live and third parties can run the check themselves? That is this episode. First, the technical picture, what the watermark actually is and how it works. Anthropic is using SynthID-Text, the watermarking system developed by Google DeepMind. It works by embedding the watermark at the model level, woven into the statistical pattern of word choices as Claude generates text. A reader cannot see it. A watermark detection system can. It applies across every surface where Claude is available. The web interface, the API, Claude Code, Claude Cowork, cloud partner deployments through AWS, Google Cloud, and Microsoft Foundry. And it applies globally, not just to users in the European Union. Anthropic's Help Center states, marking will apply to output from supported models wherever Claude is offered, worldwide. The regulatory trigger was EU AI Act Article 50, which became enforceable on August 2, 2026. It requires AI providers to embed machine-readable marks in generated content so that downstream users, platforms, and regulators can identify AI-generated material. Anthropic signed the EU Code of Practice on Transparency of AI-generated content in July. The watermark is how they are complying. For older Claude models, those released before August 2nd, Anthropic says the watermark is coming. No stated timeline, but they have committed to retrofitting the older models and say they will update their support page as it becomes available. If you are using an older Claude model today, the watermark is on its way. The most important thing in Anthropic's own documentation, and the thing that most general coverage has not addressed properly, is this distinction. The watermark marks Claude's involvement, not Claude's authorship. Those are different things with different professional implications. Anthropic acknowledges this directly. The mark signals that Claude processed the text, not that Claude wrote it. A lawyer who asks Claude to proofread their submission will receive back a Claude-marked document. A lawyer who asks Claude to reformat a table will receive back a Claude-marked document. A lawyer who asks Claude to translate a letter will receive back a Claude-marked document. In every case, the document carries the watermark, regardless of how much of the output represents Claude's own generation and how much represents the lawyer's original work that Claude processed. The professional conduct implication nobody in legal AI is currently discussing is this. If a detection API can flag a document as Claude processed and a court or a regulator runs that check, the question they are asking is not whether Claude wrote the document. The question is whether Claude's involvement was disclosed. The watermark does not make that disclosure. The lawyer still has to. Every workflow on this channel produces a watermarked output. That is worth stating clearly so there is no ambiguity about what this means in practice. A client advice letter produced using the 6-field brief and the first draft prompt, watermarked. The 3 refinement reads run on that letter, each one produces a watermarked output. A contract reviewed using Claude, watermarked. A skeleton argument drafted with Claude's assistance, watermarked. A document Claude proofread, watermarked. The watermark travels with the text when it is copied and pasted. A document that passes through Claude at any point in its production, even if the lawyer subsequently edits it substantially, carries the mark forward. Light editing does not remove it. The translation case is particularly instructive. A document Claude translated is watermarked because every word in the translated version is chosen by Claude, even if every word in the original was written by a human. The watermark does not ask whether the underlying idea is human-originated. It marks Claude's word choices. In a translation, every word choice is Claude's. The watermark is also not a complete system, and the limitations matter for how lawyers should think about it. A complete rewrite removes it. Anthropic acknowledges this directly. If a lawyer takes Claude's output and rewrites every sentence, replacing every word, the watermark is gone. Anthropic also notes that in that case, it is genuinely arguable whether the resulting text can still be described as Claude-generated. The watermark catches involvement. It does not catch wholesale laundering through human rewriting. The detection API is not publicly available yet. This is the most practically significant limitation for right now. Anthropic has confirmed that a text detection API is coming, one that developers and organizations can use to check for the watermark in a specific document. Until that API is live, no court, no regulator, and no opposing party can run a watermark check on your documents. The watermark exists. The external means to detect it is still coming. One clarification worth making: AI detection tools that currently exist, tools that look for statistical tells in AI-generated writing, characteristic phrasing, sentence structures that are more common in AI output than human writing, those are different from watermark detection. Anthropic's documentation makes this explicit. A document that passes an AI detection tool is not necessarily free of the watermark. They are checking for different things. The professional conduct question the watermark creates is not fully resolved, and the honest position is that the guidance in most jurisdictions has not caught up with what the watermark changes. For court filings, multiple U.S. courts have standing orders or local rules that require disclosure of AI assistance in court filings. The watermark does not satisfy these obligations. If your jurisdiction requires disclosure that AI was used to draft or substantially assist with a filing, the watermark is a machine-readable technical mark. It is not a representation on the court record. The lawyer's certification on the filing is the disclosure the court is asking for. For client documents, the disclosure question for client correspondence and advice letters is different from the question for court filings, and less settled in most professional conduct frameworks. What the watermark creates is a permanent, verifiable record of Claude's involvement with a specific document. Whether that creates an obligation to disclose that involvement to the client is a question your professional conduct rules need to answer, not Claude's technical architecture. The picture changes when the detection API goes live. At that point, any party who wants to check a document for Claude involvement can do so. The professional obligation to disclose where it exists becomes harder to avoid when the technical means of detection are available externally. The prudent position is to build the disclosure practice before that point, rather than in response to it. 3 questions every firm using Claude needs to answer before the detection API goes live. First, what is our disclosure policy for Claude-assisted work? For court filings, what do your jurisdiction's rules currently require? For client documents, what does your professional conduct framework require or recommend? For internal work product, does the firm need to track Claude involvement for audit purposes? These are questions that can be answered now, on the firm's own terms, before a regulator or a court defines the answer for you. Second, does our information governance policy cover this? The watermark is a permanent record of Claude's involvement with specific documents. If your firm's information governance policy covers document provenance and AI assistance, the watermark is part of that picture. If the policy doesn't cover this, the watermark is now creating a record your policy doesn't address. Third, what does our malpractice insurer need to know? The watermark changes the detectability of AI use in legal work. If your insurer's position on AI assistance in legal practice has not been reviewed since August 2nd, the watermark development is a reason to have that conversation now, rather than at renewal or after a claim. The watermark is coming for older Claude models too. Anthropic has committed to it, and the timeline will become clear as they roll it out. The detection API that allows third parties to check for the watermark is not yet live. When it is, the question moves from theoretical to operational. A court that wants to check whether a filing was Claude-assisted will be able to. A regulator reviewing a client document will be able to. An opposing party's counsel will be able to. The firms that have built their AI disclosure policy before that point are better positioned than the ones building it in response to an external check. Anthropic's support page on how Claude marks AI-generated content and their full watermark FAQ, published August 15th, are linked in the description. Both are worth reading carefully if you are making decisions about firm AI policy right now. That's the episode. See you in the next one.